You got a motion filed?
Yeah, oh yes, absolutely. I actually had issues to discuss before I crossed.
But the court reporter needs to pick you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threats, and I'm under duress. I'll cross.
All right, guys, buckle up, because right from the start the courtroom is on edge. The defendant bursts in claiming he's under duress, throwing out a pile of complaints all at once. Judge Oakley doesn't let him get away with the chaos, snapping back and forcing him to pick just one motion to focus on. It's a clash of scattered defiance versus sharp authority, and within the first minute, the tension is already through the roof.
Signed by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother, wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front check.
That's fine. Just make sure you're talking to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yeah, I have a few in there that I've been repeatedly trying to be
well, which one
dismissed.
do you want to start with first?
Well, the recent one I filed, the motion to reject the swearing in and all that, based off the fact that, like I said, I was sent a default motion that I don't know how it even got signed past the day, but it was never signed or anything. I was also defaulted out the fact that there was a citation. I never even presented a court appearance.
Okay, hold on. You're giving me too many issues. You're talking about swearing in. You're talking about a default judgment. Which? Just pick one issue. We're going to deal with them one at a time. So what do you want to deal with first?
Well, my main motion. Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, what? Don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting.
I mean, that's the only civil infraction.
I have numerous. I have lots of stuff.
Hold on, that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking about that charge.
Yeah, sure.
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
I was notified. I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation. There was no date. And actually how fast it got issued raises real concerns to me. And then once I received the default in the order.
Hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I said it's in there. It's attached to my motions.
Okay. Do you have a copy of the ticket?
I do.
Okay. Then I'm going to ask you to look at that copy of the ticket, because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date. Where it says appearance date on or before, there's nothing.
Okay, but it says contact court for appearance date. That means the monkey's on your back to contact us.
I will also on the bottom of the tickets, it says if you fail to contact court within the specified amount of time. There was no specified amount of time on here. I had no idea when I was supposed to contact the court. I was dealing with trying to get my attorney.
Let me ask you this. Did you contact the court?
I was again, as I said, I had no.
Here's where things heat up. Judge Oakley zeroes in with a simple question. Did the defendant ever contact the court? Instead of giving a straight yes or no, the sovereign dodges, stalls, and dances around the truth. Oakley grows visibly annoyed, pressing until the admission is undeniable. He never made contact. This moment perfectly shows the judge's strategy, cornering him with facts.
I'm going to give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm going to take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that, actually, when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting.
Well, once again, I'm going to draw your attention to the ticket. My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I know I got the thing in the mail. When did I get this? This says that, I don't think it specifies a date.
Well, did you make a note when you received
this? This said I don't remember exactly what date I received this in the mail, but this was scheduled for March 8th.
Okay.
So that was even less than.
But what is that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and an a warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. That I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no
Okay.
notice of any sort of.
Once again, you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay.
Now watch closely, because this is where absurdity hits its peak. The prosecutor calmly points out that another judge already set aside the default months ago, meaning the sovereign technically already won. But instead of moving on, he argues against his own victory. Oakley loses it, snapping, "Why did you just waste 5 minutes of my life?" The disconnect between logic and sovereign ideology explodes into courtroom comedy.
Honorable Judge Martin, she did set aside the default on the civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No.
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Purcell did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default's already been set aside.
Yes,
Brother, why'd you just waste 5 minutes of my life?
since March 14th, Your Honor.
Which I object to that because they.
You object to your motion being
No, I
granted?
object to them setting aside my motion. And I
No,
object to.
no. Wait, listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Listen, okay, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly, he's threatening me to
No.
sue warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
The fact that I was threatened to come in and pay money or warrants.
How was that damage?
And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money, or I would have been, there'd have been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside. And Judge Green never said a word to me about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according, yeah, but that, especially now with the new Chevron overlay, that's just saying that she's just trying to set it aside.
The infamous sovereign argument finally appears, the so-called right to travel. The defendant rolls it out like a trump card, but Judge Oakley doesn't blink. With a firm tone he declares, "That's denied." I don't buy into that argument. He even reminds him that if he disagrees, the appeal process is the only path. This moment shows Oakley's mastery of sovereign tactics, shutting them down.
You can't just set my rights aside.
She's not setting your rights aside. She set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know. Did she address the money?
No, she never did. No one did. I explained in my motion.
Sir, I'm going to hold you in contempt the next time you cut her off. The first contempt, $100. The second contempt, a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right. So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At
care
some
of.
point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
You have, hold on, let me just cut to the chase. You have more than just the fact that you think you have a right to travel.
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that.
This part shifts to the prosecutor, who carefully lays out why the stop was justified, citing Michigan law and even Terry versus Ohio. She explains probable cause step by step, painting a clear legal picture. And here's the kicker. The sovereign rejects licensing for driving but gladly accepts a concealed pistol license. That contradiction slices right through his philosophy, and you can sense the courtroom realizing the—
I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of my
object.
motion.
You can appeal.
But I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honestly, Your Honor, like I said, I even have lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get. I was
Okay, but that's got
retaliating.
nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
Yeah, Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station, and we were in town, and we are in Sibley and Middlebelt, right near actually where I got pulled over, and we had discussed it and talked about it and went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then, this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him, I've already had this day. I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me, and wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. Like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference in opinion within the department about whether or not what you were doing was legal or not.
Well, I
Is that
specifically
a fair
stated.
summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. So I'm going to let the—
Here comes the knockout blow. Judge Oakley rules that the township ordinance alone provided enough probable cause to stop the defendant. Motion denied. The sovereign erupts with repeated objections, but Oakley is unshaken. I don't care what you're objecting to. That's why there's an appeal process. It's the clean checkmate of the entire hearing, leaving the sovereign's arguments shattered and the courtroom moment sealed.
That operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry versus Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry versus Ohio in his newest motion.
Okay.
Because people submit that the investigatory stop exception in Terry versus Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the Fourth Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV, which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory step, the defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
The climax arrives as Judge Oakley warns the defendant about self-representation at trial. His words are sharp. He won't take him to law school and promises to treat him like a trained lawyer in front of a jury. Oakley practically begs him to get an attorney, but the sovereign stays locked in defiance. It's a chilling warning of what's to come and a powerful close to this saga. Don't forget to like this video, subscribe to the channel,